The Levy County Sheriff spent over an hour raiding LIEnette CROOK's home when they arrested him and took all firearms away. In mere moments, I'm going to be showing you John CROOK's bond hearing in court, which happened on the 12th of July. Before I do, I want to recount the steps of this story as it was broken to me, and then the breaking news came to you. We all know What the Hales is a citizen journalist in Otter Creek and at Hales headquarters. It was Travis, the mayor of Tubetown, baby, population 1, who contacted me first. He said, my daughter just told me Levy County deputies, they just posted on their sheriff page that John CROOK has been arrested for aggravated assault. I was then contacted by Channel 20 in Gainesville, Florida. They wanted to do a full write-up on the news story, and they particularly wanted a comment from me, which I refused, but I did give them the information for Wes Dockery through Travis, the mayor of Tubetown, who had his information. They also asked permission to come out and film on my property and to meet with my employees, which I agreed. And then the strangest thing in the world happened.
If you want to get the other side, you can come talk to us.
Would you want to talk?
I would love to.
Okay, give me like a couple minutes.
You got it.
Got to get the blessing blocks full so it looks good.
Oh, yeah. Toward that. Out in the street.
Hi. I told her I'd be over here in a couple minutes if she wants to talk. Thank you. I'm okay with it. Yeah, I appreciate it.
Sorry.
No, didn't check, no, didn't check.
Come on in. Yeah, come on in.
This fool is in 3 court cases with me and has been told to keep her mouth shut by her legal counsel. And she's in another court case in regards to the family trying to save Harley. I'm going to show you the exact news clips that came out on Channel 20. Now keep in mind that myself and Channel 20, we have a symbiotic relationship. I let them come out and get the story. They let me use their actual clips. There's permission.
A man was arrested in Otter Creek after deputies say he threatened fans of a local social media influencer. We'll tell you how victims and those who know the suspect are saying about the incident. People are coming to Otter Creek from out of state because of a social media influencer. And one person says they were threatened, and another man will now face a judge tomorrow because of it. TV 20's Kayla Lewis breaks down the 2 sides of the story.
Right behind me is a place called Tubetown here in Otter Creek based on a YouTube channel. Wes Dockery was visiting with his family from Illinois to come and sign this guest book. But he says when he was leaving, the neighbor across the street pulled out a gun.
For my 8-year-old to see that, and then she just was crying.
60-year-old John CROOK is in the Levy County Jail and charged with aggravated assault after he was accused of threatening Dockery and his family last week. Dockery says CROOK yelled at them, so he rolled down his window.
And I was like, what'd you say? And he goes, do whatever you want. I was like, what? And he goes, do whatever you want. Yelled it again. I'm like, what are you talking about? And he goes, you're going to lose anyway.
But there's two sides of the story. Cook's ex-wife, Michelle Preston, wasn't home when the incident took place, but doesn't believe Cook would do that.
He said that a man had drove by slow filming and that the man had shouted something to him, and he had been behind the magnolia tree.
Dockery says after Cook yelled at him, that's when Cook pointed his gun at their car.
And I'm thinking, if I pull off, is he going to start shooting or what? So I want to try to talk him down.
Preston says Cook was at home, and if he did pull out his gun, he had every right to do so.
Instantly threw it in reverse, and when he did, his hand came out the window with something held out the window. John doesn't see very well. He couldn't tell the difference between a gun or a phone.
Levy County Sheriff's deputies say lack of evidence and conflicting statements hampered the investigation before a warrant was served. After that, evidence of the supposed assault was recovered, as well as the gun. In Otter Creek, Kayla Lewis, TV 20 News.
Let's break down what LIEnette says on camera a little bit. But before I do, let me share that I have a very good relationship with Channel 20. And Kayla was over there interviewing LIEnette for over 30 minutes. You see just seconds. They have over 30 minutes of tape, which I have then gone to Channel 20 and said, I need you to preserve all of that as evidence in court, which we will now be using as evidence in court against LIEnette. And you say, can you? Well, of course. She told Judge Craig DeThomasis that she's paralyzed to her property and she never goes anywhere. She can't leave because she's so scared. And what's the first thing? She wasn't home. So number one, she's a not credible eyewitness. She wasn't even there. So she's lied to the courts, first and foremost. She's not home. There's not even a home, but we'll just say home as in 1.66 acres of a turd purgatory. All right, let's go a little bit further in this. LIEnette is the one that constantly has posted, and we have all the screenshots, that Crook is abusive. LIEnette, she's the one, always throwing him under the bus. All right, let's keep going. She did this in court documents. Let's keep going. LIEnette stating that he can't see. All right, let's ask this question right now. Who in the world allows somebody who can't see to have a firearm? What is an individual who can't see doing with a firearm in their possession in the first place? Now, do you think CPS has knowledge of this? Absolutely. LIEnette has incriminated Crook and herself yet again by publicly speaking, publicly posting. And we'll get to the public post. So does CPS know about this? You better believe it. I already know the biological family is all over this. They even had a meeting with their legal team all about this particular incident. And LIEnette stating Crook can't see. He can't tell the difference between a cell phone and a firearm. Then why does he have one? Because what's going to end up happening? This child is going to get pew, unfortunately. Because you know, there's coyotes all over the property attacking the dogs, killing the dogs. Remember, we've heard all of that on court, during court as well. LIEnette goes on to run her mouth, publicly posting, innocent until proven guilty. There are two sides to every story. Yeah, there's the truth, and then there's her lies. That's the two sides here. You see the evidence on what the hails. You see the proof on what the hails. You just hear LIEnette constantly telling the Levy County deputies that I'm guilty. Remember, I'm guilty of third-party contact because somebody's playing a what the hails video. How in the world I thought there were two sides to every story. My side is coming soon. Innocent until proven guilty. Yet she doesn't say that about me. She just says I'm guilty about absolutely everything, even though I've done literally nothing except broadcast what's happening in my life on a daily basis. In her Standing in My Trash page, remember that she stated to the judges she only uses for Bible verses, for biblical encouragement. All right, let's see what she has to say. She has to say, ours is coming, stay tuned. meaning her truth. There's only one truth, absolute truth. Truth is not relative. Truth isn't my truth versus your truth. There is absolute truth. That is the only truth that exists in this world. How this current culture got that screwed up, go figure. And then she goes on to say, I can't explain anything right now. It's an active case, but the truth will come out. Oh, yeah, you know we're going for a huge, long rant right now. But the truth will come out. It seems to me that the truth already came out. That's how the Levy County Sheriff were actually able to raid and arrest Crook and take all firearms. Okay, so she goes on to say, God has us now and has had us in his arm. A hedge of protection has been covering us. If that's protection, I'm not sure. I'm just going to leave it there, okay? It's obviously, number one, she doesn't know who the one true God is. It's beyond evident. Number two, they both need God desperately in their lives. They need to come to a point of relying on God and God actually having them. They would never have acted this way or done these things, potentially, if they actually changed their lives and turned it around for God's glory instead of them seeking handouts and grifting. All right, keeps on going to say, my child is suffering. I'm suffering. John has been suffering. It's taken its toll on these lies and false allegations. Now, let's just stop right there. Does everybody recognize and realize that, number one, if we back up a little bit, that if the Ohio judge took all the firearms away, which she did not, this could have never happened in the first place. John would be a free man right now if the Ohio judge did that. Now, the Ohio judge did not. And I'm conflicted right now going, well, should I be happy that she didn't and this is what got him in jail? But the other side is absolutely not. This should have never, ever happened to an 8-year-old, to an adult male, to an adult female. This should have never, ever happened. They should have, number one, respected and adhered to the cease and desist, because they didn't. They found themselves in court. Number two, if we can go back even further, they should have never even stalked us trying to get money and promotion. They've got plenty now. John's even on TV. So we can go all the way back. If they were actually doing the right thing, they would have never stalked us to Otter Creek, period. Now, anybody can live anywhere they want to live. I can't stop that. Nobody can stop that. But they should have honored the cease and desist. If they were still going to stalk us, they should have shut their mouths. They should have stopped. Instead, what they did is intensified and intensified and intensified. And they've continued to intensify. As you can see, the intensification right here that she only uses for Bible verses. Okay. All right, so John has been suffering. It's taken its toll on all these lies, these false allegations. No, we've never shoplifted or stole anything. You think I'm joking? All right, so keep this in mind, okay? Keep this in mind, because we're going to get back to this theft thing. And keep in mind that her grandson is now on the property as well, and he was just arrested for theft. So we've got Walmart knowing and alleging that LIEnette and CROOK are skip scam artists and they're stealing from them. This isn't anything new. She's already has theft. Well, she's been found guilty of theft in her life. Her grandson has now been found guilty. She goes on to say, no, we don't. And we have not unalived animals. Not the word she used. She used the M word. We have not unalived animals, except we have all the screenshots where she has unalived the animals. Jamie Starr Johnson sent us all the information about her unaliving the animals. All right, let's keep going on. Yes, I was an avid hunter and a trapper all my life. And yes, I've put an animal down. Whoa. She just said they don't unalive animals. Wrong shirt. All right, and I've put animals down that needed to be humanely put down, but I don't unalive animals. What you're seeing is a smoke screen, a mirror. You guys see any smoke? I don't see any mirrors either. I see nothing except for the truth. I show exactly what it is. You're seeing a smoke screen, a mirror. Okay. I'm seeing a screenshot. That's what I'm seeing. A mirror, a lie making us look like animals in a zoo for 2 years now. Whoa, whoa, whoa. 2 years. I've been in Otter Creek for 4 years. She told everybody that she was in Otter Creek before me, that I stalked her there. But now it's 2 years. By the way, I've only been sharing this story for just over a year now. We put up with this insanity for a year as they have been bringing chaos into the entire town and the people's lives. All right, we are not animals on display. Oh, she said in display. I do not, and I've never taken math, except take that A out and put an E. You know, messed up. I do not take any rugs except prescribed by my doctor. I do not do rugs or strong drink. I've spent my life putting people in Teen Challenge to help them get free from the bond of rugs. Well, it seems like she spent all of her time in Otter Creek putting them in tents and, you know, sheds illegally. And then claiming that they all stole everything from her, took everything from her. But let's keep going on. If everything said about us were true, we'd be gone a long time ago, right? Think about it, people. Open your eyes. I make no money from YouTube, nor Facebook, nor any other social media. I can't give all away, but I will say you're smarter than this. I know you are. Open your eyes. Okay. Here's what I want you to do. I want you to follow LIEnette's advice, because this is very true. You should never take what one person on YouTube says as the gospel truth. You should actually dig and find the information. There are plenty of people out there that they only have a viewership because they say negative things about me and they tell lies, and that's character defamation, and they will be held accountable and responsible for that. There's no truth to it whatsoever. So let's see what the legal system says about this as you open your eyes and you see the truth.
John Cook, 2407-2516. John Cook. Good morning, Mr. Cook.
Good morning.
Mr. Cook, you're being held on a charge of aggravated assault with a deadly weapon. Do you understand your rights as I've explained them to you?
Yes.
Can you afford to hire your own lawyer?
No.
Would you like for the court to appoint the Office of the Public Defender to represent you?
Yes.
Thank you, I'll do so. And we'll hear from the state.
Your Honor, he does have a prior failure to appear as recent as 2016. He has no other history since 2016. He does have prior adjudications of violence. I believe the most recent, and that is 2003. The state would request that a bond is set and would defer to the court.
Thank you. On behalf of the defense.
Your Honor, I'm unable to confirm the history at this time. I don't have that Levi County paperwork, but we would just request a reasonable bond.
Okay, thank you. Mr. Cook, the court does find probable cause for the charges. As a condition of any release, you're not to have any direct or indirect contact with the listed victim, Wesley Dockery. Do not call, text, write. Do not try to contact Mr. Dockery through social media, through a third party. No contact whatsoever. Jail staff just handed you a copy of the no contact order. As a condition of any release, you're not to possess any weapons or firearms. If Given the allegations contained within the arrest report, the court is going to set bond in this matter, and bond's going to be set at $75,000. Thank you, Mr. Cook.
And was the public defender appointed?
I didn't hear you.
Was the public defender appointed?
Yes, I did appoint the Office of the Public Defender. Thank you.
Thank you, Your Honor.
As of right now, the state is going after one aggravated assault with a deadly weapon without intent to unalive. Now, here's my question for Levy County and for the state's office. Anytime somebody pulls out a firearm, that intent is to unalive somebody. You never pull out a firearm unless you have that intent. Now, we know that Crook sometimes carries a 9mm. We don't know every firearm they have there. I carry a .45 when I legally have my Second Amendment right that hasn't illegally been taken away from me by Judge Craig Thomas's. The difference is a 9mm typically will maim, whereas a .45 will unalive. Because when you pull out a firearm, the intent is always there to unalive somebody. Now let's look at bond as well. $75,000 in bond. So what does that mean for Crook? That means Crook has to come up with $7,500 as a down payment for the bondsman or bondswoman to help him through this process. Lump sum cash. And then they have to have the rest of the money somehow as well as collateral. Well, what do they have? They've got 1.66 acres that they overpaid for. They do not have a home. They have a camper that they actually have a mortgage on. They have a Jeep that they have a mortgage on, and sheds that they illegally live in. The reality of Crook getting out of jail in time on this bond of $7,500, 10% down payment, is between slim and none. So, is he going to be at his Ohio hearing in just a few days? My guess is no way. And as such, I don't even think he'll be on Zoom. He will be, by default, found guilty. The thing I find most concerning, the day that Crook is actually arrested for this, the state drops all potential charges against him and LIEnette for breaking this civil protection order, which they are actually going to be in court in just a few days in Ohio. So now, where we had hope that things were going to the 5th District in Ocala, now we are losing all hope. As it says here, in the County Court of the 8th Judicial Circuit of the State of Florida and in Levy County, State of Florida versus LIEnette Preston. Again, I'll show it to you right here. You can see it right there, LIEnette Preston, and I'll scroll over for the charge. Violation of the injunction. It's going to be the exact same for Crook. And they literally go on to say, comes now the state of Florida by and through its undersigned assistant state attorney announces that it will file no information in the above entitled case cause based on the following grounds. After a review of all the video evidence and reports in this case, the state has determined the likelihood of conviction is slight, and therefore this case should not be prosecuted. Can you freaking believe this? An hour and a half of violating a civil protection order. An hour and a half of purposefully, intentionally being at town hall while George is there when she is mandated by the law to leave, when he is mandated by the law to leave. And the state is now going, nope, the likelihood of a conviction is very slim. I don't care if the likelihood is slim. Convict them. This is so cut and dry. Are you allowed to be within 500 feet of George? No. Did you know George was there? Yes. I actually had my camera out filming her. And then I sent it to the deputies, which Jeremy has a copy of. And I sent it to Silver Scam, which Jeremy's going to have that subpoenaed as well. All the proof is there. There's nothing slim about it. They're going to court in Ohio for it in just a matter of days. And guess what Ohio is going to do? I'm going to say they're guilty. How is it that Ohio has found them guilty on everything, and somehow in this ridiculousness of Florida corruption, they're letting everything slide to the point of when a firearm is pointed at an 8-year-old girl, a child? It should never, ever get to this point. They keep emboldening them. They keep empowering them. And somebody's going to get seriously hurt by them. Here's another one they dropped on LIEnette. This is when LIEnette texts me. They have all the proof. And they go on to say this. Although it is clear from the evidence that LIEnette Preston sent a screenshot of a prior text message conversation to Jeremy Hales, it's unclear that she did so willfully. Excuse me? She even admits she did it. And they go, it's unclear she did so willfully. There's only one individual that could send that. It's her. Now, if I would have done this, I would have been arrested immediately in Florida, wouldn't I? You know that. I know that, right? She's not from Florida. She's not one of their own. So where does this corruption circle start and where does it end? This is so ridiculous. And then it goes on to say the state would have to prove Miss Preston willfully violated the injunction for protection. Miss Preston claims that she believes she was sending a screenshot to Mr. Hale's attorney. Oh, okay. So another lie. And because she lied, we're going to let her get away with that. This the insanity of all this. I can't believe, I cannot believe any of it. If I did any of this, they would immediately arrest me. If they do it, they go, oh, well, there's a slight chance of actually finding them guilty. Therefore, we're not even going to pursue it. And yet Ohio says guilty, guilty, guilty. It's so cut and dry. Guilty. No communication. Guilty. Don't say his name. Guilty. Don't talk about him. Guilty. Don't do this. Don't be within 500 feet. Guilty. It's really, really easy. So now Crook is finally in jail for not what he did to me, for what he did to somebody who came to visit my property. So is that what it takes? Seriously? An 8-year-old child. He's got one count already. Now there's another female and a child. It will add up from 1 to 3 counts. Where are they going to come up with the $7,500? Well, here's what I can tell you. Residents of Otter Creek, keep your eyes on all of your prizes. You've got Landon there, who is a foul-mouthed, little Hitler-looking child who's already been found guilty for theft, and we all know there's enough theft in Otter Creek already. He's there because of theft. That theft isn't going to end anytime soon, in my opinion. Lock everything that you have that's valuable. Bring it inside, lock your doors. These thieves are out on the loose, trying to make a little change to get Crook back out on the turd purgatory.